Did you know that even if an employee is guilty of a misconduct, they can still be unfairly dismissed if you don't follow the correct procedure? So the Labour Relations Act says that you should look at substantive fairness as well as procedural fairness. We did touch on this in a previous video. So today I just want to share some tips on how not to make mistakes or skip crucial steps when it comes to disciplinary processes. When an employee is charged, you need to make sure that the charge sheet sets out the charges clearly. You must say what happened, on what date this incident happened, and give a description of what happened. So I always say when, why, where. This must be reflected in order to give the employee a fair chance to prepare for the disciplinary inquiry. Otherwise, the employee can just come to the inquiry and say that they weren't aware of the charges and couldn't prepare themselves properly. Secondly is the notice of hearing should be given at least 48 hours prior to the disciplinary inquiry. Also, to give the employee a fair chance to prepare witnesses and get any documents that they need to get to prepare for the hearing. Another crucial step or important point that employers often overlook is using a biased chairperson. A chairperson who chairs the disciplinary hearing must be someone who does not have prior knowledge of the charges and also does not normally work for the enterprise or is from another branch. This makes sure that a fair procedure is followed. And then lastly, denying an employee representation. An employee can be represented during a disciplinary hearing by a co-employee, but not a legal representative. The only place where legal representation or union representation is allowed, not legal representation, union representation is allowed, is when an employee is a shop steward. But that is a whole new video about union representation in the workplace that we will touch on later. So follow us if you want to see that video, and we can take it from there. So just to recap, these mistakes can cost employers at the CCMA or Labour Court. Know your rights and make sure that you follow the code of good practice when it comes to dismissals. And if you need any guidance, you can always reach out to KJVR Attorneys and we'll help you make the right decisions and follow the correct procedures.